Deputy President of the Republic of Kenya, that is Rigathi Gachagua, which has sparked political tension in the country, was presented in Parliament on Tuesday afternoon. This came after several complaints failed to be submitted in court to halt the progress of the case against the second-in-command. As our reporter Emmanuel Marwa explains, National Assembly Speaker Moses Wetangula had approved the motion, although for him it will not be a walk in the park.
Marakwet West MP Timothy Kipchumba Torwaitich has called for Speaker Moses Wetangula and the Deputy Speaker to recuse themselves from overseeing the impeachment proceedings against Deputy President Rigathi Gachagua. The move came during a heated session in Parliament, which saw the motion for impeachment gain overwhelming support from MPs. Torwaitich questioned the impartiality of both Speaker Wetangula and the Deputy Speaker, claiming their prior comments on the matter showed a bias that could jeopardize the fairness of the hearing.
Honorable Speaker, we need to give the Deputy President a fair hearing. Honorable Speaker, it is on record. As you sit, Honorable Speaker, you are a neutral arbiter in this matter. This chamber sits as a trial chamber and is similar to the High Court pursuant to Article 125.
This is not a trial chamber
of the Constitution.
Tim,
Honorable
the trial
Speaker,
chamber is the Senate.
Irrespective of that, as we sit, Honorable Speaker, you are a neutral arbiter in this House. Honorable Speaker, it is on record that you have made a pronunciation or you have known to have taken sides on this matter. Honorable Speaker, as a neutral
Now, moving on, Kericho Governor Dr. Eric Mutai has been charged following a motion presented in the Kericho County Assembly by 31 ward representatives out of the total of 47 representatives who voted in favor of his removal in the first stage within the Assembly. The motion was presented by Sigowet Ward Representative Kiprotich Rogonyi, aiming to oust him over the following accusations. Number one, serious violations of the Constitution, abuse of office, misuse of public resources. Caroline Muthoni, the rest of the details.
Impeachment motions are no longer new within the August House. Since the start-off of the devolved units of government, governors have been called to account via an impeachment threat or summons. Former Embu Governor Martin Wambora was successfully impeached by the MCAs in 2024. This was less than a year after elections. Former Kiambu Governor Ferdinand Waitito was also impeached by the MCAs in 2020 and the decision upheld by the Senate. Former Nairobi Governor Mike Sonko was also impeached in 2020 by MCAs and senators approved his removal from office. Former Wajir Governor Mohamed Abdi Mahamood was impeached by MCAs in 2021, which was 4 years after elections. Former Kericho Governor Paul Chepkwony was impeached in 2014 by MCAs but was reinstated by senators. Former Murang'a Governor Mwangi wa Iria was also impeached by MCAs in 2015, but the motion did not pass in the Senate. Former Taita Taveta Governor Granton Saboja was impeached by MCAs in 2019, but senators did not pass the motion. Kirinyaga MCA impeached Governor Anne Waiguru in 2020, but senators returned her to office. Governor Mwangaza was first impeached by the County Assembly in December 2022, but an 11-member Senate Special Committee later found that none of the charges against her was proven. However, on the 21st of August 2024, senators voted to send her home based on the 3 charges in which she was found guilty, becoming the third governor to be removed from office by impeachment after Kiambu's Ferdinand Waitito and Nairobi's Mike Sonko in 2020. Today, the list goes an inch longer with the impeachment of Kericho Governor Eric Mutai, with 31 members voting in favor of the motion. Impeachment stems from allegation of gross constitutional violations, abuse of office, and misuse of public resources. The motion was introduced by Sigowet Ward MCA Kiprotich Rogonyi. Initially, the Assembly had anticipated Governor Mutai's presence for a defense against serious charges. However, He was absent and instead sent a legal team led by Katwa Kigen. An alleged court order that Mutai claimed would halt the impeachment proceedings was reportedly not served in time, allowing the motion to proceed as scheduled. Rogoni has accused the governor of several serious offenses, including leading a mob to seize private land in Kericho town for use of an approved dump site and coercing women into inappropriate sexual activities.
From office of the governor for Kericho County, Honorable Dr. Eric Kipkoech Mutai by impeachment has been supported by 2/3 of the members of the County Assembly of Kericho. I therefore declare that the motion is passed and the governor, Dr. Eric Kipkoech Mutai, stands impeached by the County Assembly. Based on the foregoing, I give the direction that the 2/3 of the membership of this House required to pass the motion for impeachment of His Excellency the Governor is 31 members.
The governor's fate is now in the hands of the Senate, where the County Assembly Speaker is expected to write informing them of the governor's impeachment. With the Deputy President impeachment ongoing, we cannot help but wonder, will Gachagua be the first Deputy President impeached from office? Muthoni Caroline, EBN TV.
The national government, through the Ministry of Health, has announced that 85% of Kenyans have already enrolled in the new SHA health insurance system, which was launched yesterday. As reforms follow adjustments made in the health sector under the leadership of the Kenya Kwanza government, citing more benefits from the previous NHIF insurance, which has been restructured to better serve patients in the country.
Services and the implementation of development projects have been paralyzed due to delays in release of shareable revenue by the National Treasury. Many counties have made arrangements with money lending institutions to ensure their workforce is remunerated, but this arrangement has become costly due to monthly salary overdrafts, and we hope that this situation will not push our workers to take drastic measures which we have experienced in the past, which include drowning their tools and what we have just been through in the last few months with the doctors and the other health workers, including the clinic officers. This is something we need to discuss and have a sustainable solution so that we can have our civil servants who work in the health sector provide services uninterrupted so that we can be able to achieve the UHC. It is not possible for me to conclude my remarks without mentioning human resource for health, which is a critical pillar in achieving UHC. As you know, human resources are central to health services delivery, and county governments continue to prioritize and step up human resources for health capacity, both in terms of numbers, distribution of skill sets, and despite this, remarkable progress has been made to ensure that the pillars continue to face solutions that are tailor-made to deliver to this cause. Our counties continue to face challenges, partly because of the late disbursement from the National Treasury, and it is my hope that this meeting.
Now, patients at Migori Level 5 Hospital continue to suffer after the government launched the new SHA health insurance system yesterday. The transition has made it difficult for patients to pay hospital fees upon discharge, posing a significant challenge. Many patients in Migori County Hospital have been forced to pay directly for their treatments, as a large percentage of Kenyans have yet to register in the new system. Doctors have complained about delays in the implementation of the necessary equipment to process the SHA health insurance payments, urging the government through the Ministry of Health to expedite the process to reduce patient congestion in hospitals.
Had not come by the first day of this SHA. Now the patients are coming, some of them were capitated here last quarter. Now there is no capitation. They've not been registered to SHA. So it gives us a lot of challenge that we are just treating them through cash. Some, those who cannot pay cash, are just supposed to wait for their relative to send them cash, because even the gadgets that the government promised that will be installed are not installed. Received these gadgets late last evening. Between today and tomorrow, we shall be doing distribution of the gadgets which will be used for registration in all our health facilities, including the private health facilities, because people get even health services in our private facilities within Migori County.
We have a team that is ready to oversee the process. We have coordinators at sub-county level, and the organization is that will definitely have hubs, mini hubs and spokes, so that the spokes are those level 3s and level 2s that will be linking patients from that low level to either mini hub or hubs.
Welcome to the newspaper review. Kicking us off is the Star newspaper. The deputy president under pressure to quit and seek asylum. Impeachment devastating and could ruin the deputy president's political future. Gachagwa's allies fear a state clampdown would soon be launched after dossier is put out. Now, that is what the Star is going with. Of course, we know that this all, we all know that this impeachment process is really taking the voice of the dailies. Adani is now, when it comes to the Adani issue, we're quiet. Anyhow, clerics oppose government plan to tax and police churches. Of course, there is the clergy there. Association of Pentecostal and Evangelical Clergy of Kenya, National Chairman Reverend Frederick Ngugi and Bishop Joseph Maisha of the Coast Region point to the President's signature, which he appended on the MOU between the church and his leadership on the 5th of May 2022. And then on the other side, we have the President William Ruto makes a move on a chessboard during the opening ceremony of the Magical Kenya Travel Expo at Uhuru Gardens that happened yesterday. Now, down there, Senator Asigi among Time Magazine's 100 global influential leaders. I wonder what for. Now, Kiambu man, 30 years, arrested after hacking grandmother to death in quarrel over guest food. World Bank pledges 65 billion to transform city rail network and help decongest Nairobi. It's okay that they're pledging, but let's wait and see if this railroad or the city rail network will really come into fruition. That is the question. Story about the Kiambu man, will try and touch on it. That is as of tomorrow during the drift. Now, Road to Tokyo Athletics Kenya Unveil 2025 program is cross-country events rise to 6. Now, there we have the sports PS Peter Tum, Olympian Margaret Chelimo, javelin thrower Julius Ego, and Athletics Kenya President Jack Tuwei. Together, they stand for a photo while wielding the Road to Tokyo banner. All right, and that is what the Star has for us this day. Then we go to the Daily Nation. Chief nightmare. Doctors cannot treat patients before getting clearance from Social Health Authority. There is that back and forth now across the country. Patients are enduring a medical crisis of unspeakable horror. Their up-to-date NHIF cards have been disabled, while the new healthcare plan is yet to take off due to rollout glitches. The transition meant to safeguard Kenyans' health and ease their suffering has instead left them stranded and in pain. Is a story that the Daily Nation has decided to focus on. Of course, impeached Kericho MCA's vote to send Mutai packing, then outrage over 7-year term for president. That is a bill being a proposal, yes, to extend the term of the president and other elected leaders from 5 to 7 years. Now, my question will be, if those who are legislators, makers and changes of what is entailed in the Constitution decide to sit down and want 2 more years, of course that bill is likely highly to go through. That's a sad state of affair. At the back of the Daily Nation, of course, puzzle of broke counties with 42 billion Kenyan shillings in accounts. I remember we did a story about that, saying that now counties are plunging into debt, and that's just sad. Now, the Standard newspaper, Ruto's loud silence. President Ruto, who quietly jetted back from the US on Monday, steered clear of his deputy Rigathi Gachagwa's tribulations, even as Parliament began the process of removing him from office, perhaps signaling that the head of state is supportive of the historic move. And as the deputy president turns his attention to the Senate, where the trial proper will be conducted, it will be an uphill task, winning over at least a third of the 67 senators needed to scuttle the motion. Yes, that is what is at the very center of the Standard. Then, woman detained over child sexual abuse claims. A sad story. New social health insurance serves patients more pain. Then why state could lose 7 billion shillings in Hustler Fund. Of course, we know the state is trying to make every way possible to gather back the money lended in the Hustler Fund project. Then we have New Jobs Hope fades over slow growth, and then Israel targets Iran after Tel Aviv attacks, and then of course Manchester United Porto test for Ten Hag, which is also, of course, at the back of the Standard newspaper. Ten Hag demands Manchester United response in Europa League, which now sums up our newspaper review. I think most stories, the top stories will be Gachagwa's ouster motion and the different reactions here and there that we've seen, and of course the SHA rollout. Are we really going to better, or just making a roundabout? We're turning round and round and round among the same issue, just different names. Same monkey, different forest. Now, that marks the end of the newspaper review and also my time for today on the newspaper review. However, I leave you under the hands of our advocate, Charles Kamenza, and together we'll be discussing on family law matters, family, and I do hope that you're going to enjoy the discussion that will come. My name is Consolata Chibalonza. See you.
Regional jurisdiction on every part of this country. So it basically depicts the supervisory role of the High Court in supervising every other institution that administers justice. So magistrates, court and tribunals and boards have limited jurisdiction, either territorially or subject matter. But the High Court has unlimited original jurisdiction, so that's why it has the supervisory power of advocates as ministers of justice.
What can a senior counsel do that an advocate of the High Court cannot do?
No, for you to be a senior counsel, you have to be an advocate first. The difference is how many years you've practiced and then what contribution you have, so that you are nominated and then you are appointed you are conferred the rank of a senior counsel. It's a rank within the profession.
Oh, yes. It's a rank. So there's nothing like maybe there's nothing as maybe a senior counsel can go to the Supreme Court, but an advocate of the High Court cannot.
No. As long as you are an advocate of the High Court, you have the right to have audience before any court in this country.
Supreme Appeal,
yes.
High Court.
Yes.
All
Supreme
right.
Court, Court of Appeal, High Court, any court, even tribunals. Yes.
Right. That's the little bit about the schooling there. And I remember I also asked this because I remember Ferdinand Waititi was in court yesterday, if I'm not wrong, and I saw Senior Counsel Honorable Martha Karua represented him, and it felt weird because, you know, we're used to her being the one in charge, and now she was answering to someone else, asking for permission. That felt nice. Anyway, apart from that, something else that is going on in the country right now, of course, is the impeachment debate on our deputy president, that is Rigathi Gachagua. He is to be impeached, maybe because of, they've listed 11 reasons, but top of them being insubordination. But I will not ask you about Gachagua, I will ask you about the Speaker of the National Assembly. Both the Speaker and the Deputy have been heard. The one for Deputy Speaker was outrightly, I will spearhead the impeachment motion. For Moses Wetangula, who is the Speaker, it was a slither through saying, just quit, just let it go. But then I would ask, will that affect in any way, will it affect the outcome that we expect to get from the House?
I would not be in a position to comment on that because that would be speculating and reading the minds of parliamentarians. However, what I can say is that the Speaker, the impeachment is not a purely legal process, it's a quasi-legal process, so it has some political facets, but there are some legal requirements you are required to achieve so that the process isn't challenged by the court, and the court actually goes ahead and quashes the same. So being a quasi-legal process, it means that we don't apply the strict rules of the legal process. So you will not find a judge or any judicial officer making comments on anything that is likely to find itself before them on any question. So I think previously we have had the Chief Justice refrain from commenting on certain issues because it may get to them in the Supreme Court, and by the time it gets to them now, she is already conflicted. That's distinct because this is also a political process. So the court process is purely legal, nothing else. And so that's why judicial officers will not go out there and make comments about issues which are likely to come before them in court. And if they have made such comments, they will recuse themselves from handling such matters. However, in this case, because it's a quasi-legal process, then it means that we can't strictly say that they are not supposed to comment on the process. In fact, some of the comments they have made, if interpreted legally, it would mean, it could also be given the meaning that I am responsible for seeing through the process, whatever the outcome is, because she hasn't said this is in the case of the deputy speaker. She hasn't said that I will have him impeached or I will push for him to be impeached. She's just saying that she will see through the process, and she's legally mandated to see through the process. Same as for the speaker, it's the same thing. He is not barred from speaking on these issues. I think the best parallel we can draw is from the US recent impeachment of Trump, where you saw the Speaker of Congress, Nancy Pelosi, make comments and make their case as to why they want to impeach the former president, and her position on the seat. And she was the Speaker of the House. So because it's a quasi-legal process, you are allowed to have your views and air them. And also remember, there is a side which is prosecuting. There's someone prosecuting this case. Someone was brought to grounds, and there are people who are supporting this particular ground. So they are allowed to debate their case in public and try to convince people. When you are in a court process, you are not allowed to debate your court, anything that is going on in court outside the court. Yes.
Oh, yeah, okay. Oh, no wonder they usually say this matter is in court, we'll not talk about it. Yes. All right, well, that gives quite a very good difference. Now, maybe I would ask this. The Deputy Speaker, for instance, Gladys Shile, is a women rep, right? She represents Uasin Gishu County, if I'm not wrong. As in her position as the Deputy Speaker, is she allowed to also bring motions, to table motions to the House?
No. As the Deputy Speaker, when she is not sitting as the Speaker, because remember she is holding two different positions.
Yes.
When she is sitting as the speaker, she can't make any motion. She can only direct the debate and give verdicts on what has transpired, for example. But she can't move a motion as the presiding officer. Yes. So when she sits on the speaker's chair, she becomes the speaker, and she can't move any motion. She can only wait for motions to be moved, then give directions on how they're going to be addressed, or give verdicts as to the outcome of what a particular motion has been.
So if she has an issue or a motion to be tabled, she has to ensure that
she can't be the one now seated on the speaker's chair. Yes, it has to be.
But she's free to do so.
She is free, but not when she's seated.
Not
there.
when she's seated.
Yes.
Yeah.
When she comes back to the plenary, she is free to move, to make motions, and to move the House in any particular manner.
So, for instance, right now that we have this going on, the debates are going on, of course. Can she participate in the debate?
If she's not the one who is presiding.
Yeah, the one who's presiding, for instance, right now currently it's the speaker himself.
Yes.
Is she allowed now to participate?
Yes.
It's okay for her to participate?
Yes, yes.
All right, good. I think that's all for today's recap of what is happening in our political society. Maybe if you have any further questions, you can hit us up on EBN TV across all social media platforms, and for sure, we shall be able to share the questions with advocate, not lawyer, our advocate, please. All right, so let's get to the family court. Our family is a very interesting thing. It's intriguing, it's big, it's huge, it's important, it's vital, and at the same time, it's very delicate. We want to talk about, especially, mostly about inheritance. But before we even get to the inheritance part of it, there's this singlehood. I don't know how to phrase it per se, but we have a lot of single mothers, a lot of single fathers situations going on out here. I would like before you, Wakili, to tell us. I was reading a story the other day, and I saw, well, it didn't happen here in Kenya, but I realized that in Kenya, very many people are coming to the courts because of family struggles, especially when it comes to mom versus dad. The rights of the child. Where does the child go? What does the mother deserve? What does the father deserve as a result of having the child? So first and foremost, let's just talk about the right to the child. That name is disappearing, oh, what a shame. But there's the right to the child. Who gets to have the child? Right? Custody, thank you. The custody of the child. Who gets custody at what age, and at what, is there a specific age when a mother can have the child or when a father cannot have the child? Or what are the things that contribute to custody giving when it comes to the courts?
Okay, thank you for the question. It's quite wide, so you will allow me some time to explain on it.
You have our time.
So, okay, I think the first and most basic thing I think we need to understand is that when we are in a children's court, because now we are dealing with children, the children's court, which is a special court, it's not a magistrate's court, it's a children's court, is concerned with the best interest of the child. So that is what guides children law and children practice and the court itself. So whatever else you have out there, we are concerned about the best interests of the child. So with that in mind, now when it comes to custody, there is no one hard and fast rule on who gets custody. But there are guiding principles which are both in the Children's Act, but these ones have also been developed over time. We call it judicial precedence, which has influenced what is in the Act. And so there are various factors we look at. The first is the age of the child, of course. And the general rule, and I emphasize general rule, is that any child below the age of a child of tender years, and children of tender years are 10 years and below, ought to go to the mother. The reasoning behind that is that maternal nurturing is important during those ages. And so, for example, a child between the age of 0 and 2, when they are breastfeeding and doing their prenatal development, the early developments, logically, the mother ought to have them because the father cannot breastfeed.
Provide that, of course.
Of course. So that's the main logic behind it. Between 0 and 10, the child is more reliant on the mother because the mother is the main, is what we would say is the main caregiver because of the attachment. But I said the general rule because there are exceptions.
Okay.
So for that rule not to apply, you have to bring yourself within the exception. So you have to show, for example, the mother is incapable of taking care of the child, or has endangered the child, or is not mentally fit to take care of the minor. For that rule to move away. So that's the first general rule. Then we also look at the gender. And the gender factor is that children who are male ought to go with the father, children who are female ought to go with the mother. But this more applies when you get 10 and above, 11 and above.
Okay.
The other factor, the other heavy factor usually is where has the child been staying. So you don't move a child from an environment they have been in, especially if it has been a prolonged time. So if the child has been staying with the mother, for example, for a prolonged period, let's say like 8 years or 3 years or 2 years, then you don't move them from that environment. If they have been staying with the father, even if it's a child of 10 years, for 2, 3, 4 years, then you don't move them from that environment. That's the other guiding factor. So, and then the other factor is the presence of the father, of the parents, and also their financial capability, because when you are doing custody, you also have to look as to whether they are able to maintain these children. Yes, so those are the main ones. So you will see that each case is peculiar. It will depend on the circumstances of each case, but those are the main guiding principles the court will look at when it is trying to determine the issue of custody. We also need to remember in our Children's Act, where with the one we adopted, I think it was 2020, we were trying to move to incorporate some of the principles we have in the international instruments that we have signed, especially the African Charter on the Child, and also our local circumstances. So we tried to incorporate extended family members into the equation. So one of the other factors you will find also being considered is the ability to relate with other members of the family and the extended family. Yeah. Okay.
Let's talk about when you said that there are exceptions. Of course, we understand the financial, especially when it comes to finances, the parents may not have the same financial muscle. But let me say, for instance, when it comes, if the mother is not well off, and the father is well off, the child is maybe below 5 years of age. Of course, as you had said, I agree. There's the nurturing aspect that comes from the mother that is needed by that is needed by the child from the mom, right? What happens if now the mom, yes, has the capability of nurturing this kid, but is not well financially?
Okay, that's why I said there are various factors. So you have to weigh all of them together. But the first and general rule is they should go with the mother. Now, in such a situation, you know, you also have now to consider the other elements of law, which is maintenance. And the law splits parental responsibility into 50-50.
Okay.
And that simply means that when we are looking at the needs of the child, and the needs of the child are usually defined with S5, that is health, education, shelter, clothing, and food. So we are looking at 5 needs. So when we are splitting them, naturally, the person who gets the child gets to do housing, because you stay with the child. Then clothing usually follows there, but it's not a fixed rule. But naturally, what you will find is that my financial capacity isn't usually weighing so much on the court as opposed to the other factors, because remember, we are looking at the best interest of the child. Because the court can order that you do maintenance for the child, you do provide financial support for the child. So that simply means that I can stay with the child, and if I am the one who is present, and because of the age of the child and the gender of the child, and this is where the child has stayed for the last 10 years, so then 5 years now, because they are 5 years old, then it means those factors weigh more as opposed to the maintenance. So each case depends, with the circumstances of each case. So you won't find one case determined like the other. There's no hard and fast rule. They are just various considerations we take into account before when the court is making its decision. These are what assists it in evaluating how to make the decision. So while financial factors are important, they are not the sole and principal thing. And in many cases, you will find that because the court is able to order that you provide for the minor from wherever part of the world you are in, then the other factors start to weigh in more as opposed to that. But still, financial capability is still considered. That's why if you go to a children's court, the first thing they usually do is send a children's officer to do an assessment on where the child stays, to see the environment, and now the socio-economic circumstances of the parents, so that then the court will be more informed as to what's the capacity, where they stay, and those things now combined assist the court in making the decision.
Okay, that's well put. Now, it has come to the attention of many that sadly people have been using the children for monetary benefits. Like somebody will go either trap a man, especially the ladies, sorry ladies, but if a lady will go trap a man, have relations with the man, become pregnant, and once the baby is born, the girl tries to milk money from this man. How can a man avoid this or prevent this from happening without really denying the child, but being there for the child, and without feeling like this girl is just after my money?
Okay, as I said, we are looking at the best interest of the child.
Of course.
We are not looking to enrich anyone or to take advantage of anyone when we are dealing with children's matters. So whenever you go to court, there is also something which most people don't forget, but is very important. You also look at your history in your involvement with this child. So whenever there is a child, we don't care what your relationship is like or whatever differences you've had. We are more concerned with the child, and we are concerned with providing for the needs of the child. And so when you go to court and you see it assessing, actually what we usually calculate, for example, if you are doing food, they will tell you that a child of this age will eat like 200 shillings per meal. And this is on the higher side, but I'm using just as an example. So we will calculate 3 meals in a day, 600 shillings, multiply it by the number of days in a month, and give you that as the amount. So it's not that you go and pluck a figure and just dump it on someone because you think he earns 200 or 2 million shillings, you tell him to pay 500. No. It's calculated to ensure that we are taking care only of the child. And remember, it's parental responsibility is 50-50. So if, for example, you want to live in Runda, but you're not able to pay Runda, you can't force someone to come and pay for you Runda.
But see, I want my child to live well.
Yes, but you see, you have to live within your capabilities. So that simply means when the court is also looking at this situation, it will be looking to see what are you also bringing to the table as the woman. And so we are looking to see if you are saying you want to live in Runda, a house of 55,000 or 100,000 per month, and you are saying this child needs to go, for example, to Cambridge for 180,000 school fees per term, and you want this child to dress like this, you want this, all those things will be factored in, calculated, see what the child really needs, split it 50-50, you will get your share and they will get their share. Yes, so there is nothing like being exploited. It's simply a situation where I think sometimes gentlemen tend to misunderstand what is happening. Simply because you've been told to give this woman money for food doesn't mean that you're being exploited. Whatever you're being asked to pay for has a formula where it has been arrived at. If you actually attend the children's court, you will hear them say, this child needs to eat this much, and this is why I'm giving this figure. This child needs to dress this much, this is why I'm giving this figure. This child needs to wear this and this and this is why I'm giving this figure. If, for example, school is never even an issue, much of an issue, because you'll come with a school fee structure. If there are school-related expenses, they will be costed. And so you'll be asked to pay this. If it's an issue of health, you'll be told to take a health cover, for example. So there is really nothing about where you will say that someone will exploit you. Yes, I know people, women sometimes tend to believe that they can tie you down because of that, but when you go to court and follow the process, because we have had clients who have had that where they have been threatened, but when they come to us, we tell them, let's go to court. Now, when you go to court, you will get a proper direction from the court on how much to pay, when to pay it, and who or where to pay it. Such that if you're going to school, you'll be told, do shopping for the child if it's in a boarding school. Take it, yes. If it's school fees, take it to the school.
Straight to school.
If there is an issue of school's uniform and anything, something like that. If you are paying now maintenance for the child, the court will even explain to you, this is how much it has come to, and this is why we have arrived at this figure. There's nothing like we plug figures from there. So if you are having someone's child with the expectation that you will hold them down, if this someone gets the knowledge that they can actually go to court and balance their rights out, then you yourself will be in trouble, because remember, you're also required to chip in towards maintenance of this minor.
Very well spoken. But let me ask, when you're talking about the 50-50 part of it, for example, the man earns, let's use the 2 million he had used earlier on, earns 2 million, and then this lady earns 10,000 Kenyan shillings, maybe Mama Mboga or something. But when we go to court, if we say it's 50-50, like the 10,000 doesn't even come close to maybe a Cambridge school fee. Like that, I think that's lunch only. So what do you have? What happens in such instances?
No, the 50-50 is a guidance. Okay, but you see, by the time we get to the 50-50, we have to first calculate the expenses. And when you are calculating expenses, we look at your income. If you are not able to take your child to Cambridge, we won't force you to take them to Cambridge. In fact, there are people who are told, take your child to a public school. It's free of charge. Same thing applies for example, for where you live. You can't go and live in Runda and you can't afford it. So it's not hard and fast rule. Remember, we're looking at the best interest of the child. So if you earn 2 million and the other person earns 10,000, you may end up taking more of the responsibility. But that doesn't mean we are going to milk you your entire 2 million. We'll be reasonable. You can't demand you're earning 10,000, but you want a child to go to Cambridge. That's unreasonable. So you won't find a situation where the court is forcing you to take the child to Cambridge because she wants the child to be taken there, but she can't afford it. Because remember, when I give you that, then I'll come back and tell the parent, then you have to pay for the food, you have to pay for this, you have to pay for this. And actually, most of the cases you will find is that, yes, one need is too high. Like, for example, education is usually too expensive. So you'll find one parent having been allocated more responsibilities, which when costed do not amount to as much as one need as costed. So we are trying to balance it out, not hard and fast, but at the same time not exploiting people. So when you say you want to take your child to Cambridge, know that when the court comes to balance it out, it will settle the person to pay school fees there, but now you have to, for example, foot the rest of the expenses with your 10,000. Yes. And also the court doesn't take automatically what you see. That's why they do the children's reports, and they will assess what is best for this child. Because I would imagine if you are living in a slum, but your child is going to a school like Cambridge, then the social life of the child may not be that good. So that's the other factor they will look at. So they will not order you to go to Cambridge and you are coming from a slum. They will try and balance it out to a situation where because you're looking at the best interest of the child, where the child grows and in a secure and I would say nurturing environment.
So it's safe to say that it's a fake notion, or it's a notion without basis when people say that ladies are being exploited. It only means that people have just not gone to the court.
Yes, I tend to believe so, because the unfortunate situation you will find is that in many cases the men who are in such a situation, they had an affair. They are married, they have a family, they have an affair. So they don't want it to come out. So that's why they don't want to go to court. But the ones who have courage to admit their mistake and inform their wives, or where the wife cannot find out, and you go to court, because the threat usually is, I will go public with this. But the minute you go to court, the court will tell you, pay this, pay this, pay this, and you will tell the lady, pay this, pay this, pay this. You will go to the magistrate, you will keep complaining, oh, he's not paying this, oh, he's not. The magistrate will be asking, what are you bringing to the table? So the challenge with those situations usually is that some people are, and that's why you find they feel that they're being exploited, is that they are not willing. They did things in the dark, and they want them to remain in the dark. When they come to court, you see now the court does not operate in opaqueness, so it's open, so anyone can come and see and hear of these situations, and the lady may even now go and tell your wife or whoever it is that you are in a relationship with. So that's the fear that they usually have. Yes, but if you are willing, if you are not ashamed of it or you are not afraid of it, then once you get to court, then the process flows and everyone gets to foot their responsibility.
We have had instances of where ladies have been reporting men to the court in the name of deadbeat dads, right? Is there a reverse of the same? Is there a provision for the same for a man who has brought up a child and the mother has been nowhere to be seen, and then all of a sudden the mother is back? And are there men who go to court and report that? Deadbeat moms.
I wouldn't say report it in the sense of deadbeat, because deadbeat means you're not making financial contribution. You may be present, but you're not making financial contribution. Maybe you are not capable or something, but you are present. You see, there are two things you are looking at: the presence of someone and their financial contribution. Now, for many fathers who tend to go, the ones I have seen, it's an issue of access. Many of them you'll find are paying school fees, they are paying this, they're doing everything, but they are not being given access to the child. So they go to court to ask for access. Or in a situation where you find that the gentleman wants to simply make things legally and formal. So yes, they are separated. He's not asking the wife to produce anything, but he wants to go to court to have custody and have formal arrangements on access for the lady. So yeah, there are, I wouldn't say many, but there are a few instances where you find the man is the one who has moved to the court and he's simply seeking. I've never seen a man who has gone to ask for financial support, to be quite honest, but they are seeking it's mostly an issue of access, or to legalize the arrangement so that it's well defined. Yeah, but there is nothing which prevents them from asking for it. The law is that any party can ask for maintenance of a child. In fact, it doesn't have to be the parents, it can be also relatives. Yes, if, for example, I'll give the issue of orphans, half orphans, where the aunt has been left with the child and the father was not providing, or the uncle has been left with the child and the mother is still alive, and they're feeling like the burden is too much. They can go to court as the guardians, ask for custody because they are the ones who have had the child, and ask for maintenance from the woman. Yes, so there is no rule which says that a man or a woman can't, or this is what a woman or a man can. No, we don't look at you as man or woman, we look at you as parents and the guardians.
Oh, thank you. There's a lot to unpack, and sadly we've come to the end of the show. However, I think the next time when we'll be talking about family, I think we'll get to go through the marriage route. Is that okay with you? We talk about marriage the next time we're coming to talk family?
Yes, family law is very wide. As I said, we cover marriage, matrimonial, property, divorce, children. You started with the inheritance, so that's law of succession, and other attendant areas within that area. It's quite wide, and it impacts people directly. In many cases, we will find this.
So I think, we still have to tackle the inheritance. Time is up. We'll see kufika hata kwa inheritance. We're still in the courts trying to get custody of the child, quote unquote.
And even children itself is quite wide, because we've dealt with custody, not so much so dealt with maintenance. There is adoption, guardianship, foster care, children in conflict with the law. There's a reason why the act is
it's
that
a chapter on its own. I want to find it this month in Kwetu family law. I don't know. We'll talk about it maybe later on. But thank you very much for your time once again. Our advocate, we do cherish your input on the topics of discussion. And thank you to you, my esteemed viewer, for your time and your consistency sticking around EBN TV. We do not take it for granted. It's a wonderful evening. I will allow you to rest as I also go and rest. Wakili, asante sana once again. My name is Consuela Chibalonza. This is our advocate, Charles, and he'll be here more than I can tell. Until next time, have a good night and may the Lord bless you.